HELOC. Sorry. Kouri took out a home equity line of credit on the family home. She signed the revolving credit deed of trust using the authority granted to her by the power of attorney mentioned above. Kouri signed this deed of trust using the power of attorney because Eric was out of town on a previously planned hunting trip. Eric was aware of the HELOC prior to Kouri signing the deed of trust. The deed of trust was recorded against the family home. The HELOC funds were used in part to perform work on the home. Eric knew that the funds were used on the home, and Eric himself performed work at the home. The amended information states that Eric learned of the HELOC in September 2020. This statement is undermined by the above facts. Kouri is the owner of Kouri Richins Realty, a Utah real estate company. Eric was only a member of the real estate company for a handful of days in April 2019, at which point he was removed as a member. Otherwise, Eric has never had any ownership or membership of KRR, which is the realty company. In or around February 2022, KRR entered into an agreement to purchase a home in Utah, the Midway home. Side note, we did a little tour of that on one of my previous videos. It was up for sale, so there was pictures, so we went around it. It is now being purchased. The agreement was between KIR and the seller, and the Midway home was conveyed solely to KIR. Kouri did not execute the agreement in her personal capacity, nor did Eric execute the agreement in any capacity, as he was not a member of KIR. In other words, not only did Eric not need to sign any documents, but he played no role in executing the transaction. Life insurance policies, because there's no case without them. November 2014, Eric applied for a life insurance policy. The state alleges that Eric was unaware of this policy and Kouri obtained it without Eric's knowledge. November 2014, a medical examination of Eric was conducted prior to the issuance of the policy. The medical exam is signed by both Eric and the person administering the exam. Thus, the state's allegation fails. Fair enough. June 2017, a life insurance policy was obtained in the amount of $250,000 with an additional accidental death rider. The state alleges that Eric was unaware of this policy and Kouri had taken it out without Eric's knowledge. The premium was paid from the joint checking account. Thus, the state's allegation fails. No. She could have paid for it with the joint account. Did he sign for this one as well, or not? September 2017, Eric applied for another life insurance policy, the amount of $1 million. The state alleges that Eric was unaware of this policy and Kouri had taken it out without his knowledge. On October 20th, 2017, so a month after he applied for the life insurance, a medical examination of Eric was conducted prior to the issuance of the policy. The medical exam is signed by both Eric and the person administering the exam, thus the state's allegation fails. Fair enough. February 2022, an additional $100,000 policy was offered and accepted in conjunction with another life insurance policy. January 2022, the beneficiary of a life insurance policy intended to fund his business by sale agreement was changed at approximately 7:21 p.m. Within a matter of minutes, at approximately 7:27, the beneficiary was changed back to Eric. This might be the one where allegedly Kouri kept trying to make herself the beneficiary of all of the policies. There is no evidence identifying the computer from which the login was initiated. I mean, there might be evidence now, because remember, this was back in June. So that now we go to when Eric died. March the 3rd, 2022, Kouri made Eric a drink. He consumed around 2 sips of the drink at approximately 9:15. Kouri went and lay down in the bed with Eric for about 5 minutes. She then went to sleep in one of her children's rooms because they were having a nightmare. Eric used his cell phone over the course of the next approximately 2.5 hours. Eric was frustrated because he was trying to obtain the horns from an animal that he had recently shot on a hunting trip in Mexico. A trip, according to witness accounts, that the outfitter had not been paid for. From approximately 9:13 through to 10:58, Eric was actively discussing the situation involving the horns with a friend. At 10:50, Eric had a phone call with the friend that lasted about 8 minutes. From approximately 11:45 to 11:56, Eric was using his phone. He scrolled through Instagram and searched for how far is it from Scottsdale to Nogales, presumably based on his conversation with a friend regarding retrieving the animal horns from Mexico. Kouri woke up in her child's room at 3 a.m. When she returned to her and Eric's room, she discovered that Eric was cold and not breathing. She called 911. The dispatcher directed Kouri to perform CPR. Kouri had never performed CPR, nor had she ever had any CPR training. Based on the dispatcher's request, Kouri pulled Eric off the bed. Kouri then began performing CPR on Eric based on the instructions given to her by the dispatcher. This was the first time Kouri had ever performed CPR. Paramedics arrived shortly thereafter. They're focusing on the CPR because the prosecution alleged that it was never performed, because when the paramedics arrived, they performed CPR and Eric foamed at the mouth, which apparently is a sign that no CPR has been performed. 4th of March, when Eric's sister, Kouri Richins Benson, arrived at the family home, she immediately told investigators that she was Eric's power of attorney. Within a matter of hours after Eric passing away, Katie also contacted Eric's estate planning attorney regarding taking over and addressing Eric's finances. The estate planning attorney explained that it was very early for Katie to be addressing Eric's finances. Now, I assume they have evidence of this phone call, emails, all that stuff. It's not a nice allegation if it's not true. On the 5th of March, Kouri was contacted by a friend of Eric's who asked if he could come by the family home, not the Midway house, to offer his condolences. Several close friends and family members were also at the house or stopped by at various points during the evening. The gathering was not previously planned, but resulted for individuals stopping by to offer condolences. Much of the gathering was spent playing games with Kouri and Eric's children to take their mind off the events of the previous day. The state and the state's witnesses, specifically Amy Richins and Kouri Richins Benson, have advanced the narrative that Kouri was celebrating the day following Eric's death. Such statements are contradicted by the account of others who were present. I have heard that. I have heard that she was celebrating the purchase of a home. Instead, witnesses recall overhearing Amy discussing wanting Dad's truck with Eric and Kouri's children. Amy stayed the night at the Richins family home. March the 6th, Kouri attempted to access a safe that she and Eric had previously purchased using their joint credit card, which was connected to a joint bank account. The safe contained Kouri's personal information and documentation, including her social security card, birth certificate, and passport, among other things. It also contained documentation for Eric that she believed would be necessary to review and have accessible. Upon using the original safe code, she realised the code had been changed. Recognising that she would need the information contained therein, she contacted a local locksmith to open the safe. The locksmith arrived and began to work on the safe, but ultimately did not open it. Amy was still present and became enraged, ordering the locksmith out of the garage. Amy immediately called Katie and then told Kouri she could not do anything with the property in her house or anything with her house because it was no longer Kouri's house, claiming that the house belonged to Katie and the trust. The police were called. Witness accounts indicate that Amy escalated the situation and was never hit by Kouri. However, Kouri did push Amy and ultimately took responsibility for that conduct. This is messy. Although the locksmith ultimately left without opening the safe, Kouri was able to locate the new code and open it accordingly. The safe contained approximately $10,000 in cash. As of the date of Kouri's incarceration, the $10,000 in cash remained in the safe. Approximately 1 week later, Cody sent an employee to seize all of Eric's work electronics. Around the same time, Cody sent another employee to take and remove Eric's work truck. As a result of Cody directing employees to take Eric's work electronics and truck, the electronics were not identified or located by law enforcement for months after Eric's death. It is also unclear whether law enforcement ever searched Eric's work truck. Eric's electronics were not turned over to law enforcement for some time. Law enforcement executed search warrants on the family home and Kouri's personal electronics on April 13th, 2022 and May 8th, 2023. Law enforcement located no fentanyl in the family home. The state filed the original information May 8th, 2023. That information contains the following allegations: that Kouri contacted Lauber to obtain prescription pills. Within a few days, Lauber procured hydrocodone pills from a dealer and was directed to leave the pills at a house in Midway that Kouri was flipping. They insinuate that 2 weeks later, Kouri contacted Lauber stating that she wanted some more medicine, some of the Michael Jackson stuff, and Lauber procured fentanyl. 2 weeks after February 14th, 2022, Kouri contacted Lauber again for more pills. Lauber got the pills, and yeah, you get it. Approximately a week later, Eric died from a fentanyl overdose. The state filed the first amended information on May 18th, 2023. The first amended information is rife with inconsistencies as compared to the original information. Lauber now believes that Kouri contacted her in early 22, not 21. Despite originally stating that Kouri contacted Lauber via text message, Lauber now states that she cannot remember whether the contact was phone or text. I mean, that's irrelevant. If you've got the text messages, you've got the text messages. While Lauber originally stated that Kouri contacted her for prescription pills, she now states that Kouri contacted her specifically for fentanyl. Lauber originally stated that in the first alleged transaction, Kouri asked Lauber to deliver the pills to a house that she was flipping. Lauber now claims that Kouri obtained the pills in a hand-to-hand transaction at Lauber's home. Lauber now states that Kouri did not just request stronger pills, but specifically stronger fentanyl pills. While Lauber originally stated that there were 3 pill transactions that took place with Kouri and all took place prior to Eric's death, Lauber now states that there were only 2 transactions and 1 taking place after Eric's death. And then it goes through what the charges are and when it happened. Again, Lauber stated that she received $900, but now she's saying it was $1,300. None of this is relevant if the text messages are there. The minute details don't really matter. Lauber stated that cash was left at the Midway house. Now she says it was a check. Lauber stated that she left fentanyl at Midway house a week before Eric's death. Now she states she left the pills 3 weeks later on either March the 9th or the 10th, and that was after Eric's death. However, county records demonstrate that Kouri sold the Midway house approximately 1.5 months earlier, back in January. So, yes, she didn't own the home at the time of Eric's death, according to this. Such inconsistencies cast doubts on the credibility and reliability of the testimony provided by Lauber. In addition, the first amended information states that Eric's safe, the one that was purchased by a joint credit card, contained between $125,000 and $165,000 in cash. However, Katie submitted two separate declarations, both under penalty of perjury, that Eric told her that the safe contained approximately $200,000. Lauber was interrogated and questioned by law enforcement on several occasions. It appears the first time Lauber was questioned, the interrogation was not recorded. If the interrogation was recorded, counsel for Kouri has not been provided with that recording. The first recorded interrogation with Lauber explained that, absent her cooperation in their investigation, she would be facing very serious criminal charges resulting in jail time. Lauber is currently on probation pursuant to a plea in abeyance agreement in two separate cases, wherein she pled to 4 first-degree felony charges, 1 third-degree felony charge, and several misdemeanor charges. A search warrant executed at the time of her arrest revealed that Lauber had a firearm in her bedroom. So yeah, she's got multiple charges against her. Allegedly, the police have said, you cooperate with us, we'll go a bit softer on you. And she's not, and because she's on parole, no, probation, she shouldn't have a firearm, I believe. This is interesting. Specifically, law enforcement demanded that Lauber give good enough details that will ensure that Kouri gets convicted of murder. Further, law enforcement explained to Lauber that her life was screwed at this point for a minute or for a few days if there's not cooperation. Law enforcement told Lauber that if she gave them what they wanted, it would constitute her get-out-of-jail-free card. In addition, after interrogating Lauber for more than an hour, law enforcement told her that they needed a stronger witness because the purported details that she had given them so far were not good enough to be presented to a court. Do you think any of that's real? Like, where did they get this information from? Is it in a recording? I mean, I doubt it, but how would you prove that that happened otherwise? After such statements, Lauber's testimony changed to conform with law enforcement's story. She was then released, and then over the years she's provided housekeeping services for Kouri and was paid by cheque. This is their argument. Kouri is eligible for bail because there's no substantial evidence to support the charges. And then it explains the law. The bail statute further provides that any arrest or charge for aggravated murder is a capital felony unless the prosecuting attorney files a notice of intent to not seek the death penalty, or the time for filing a notice to seek the death penalty has expired and the prosecuting attorney has not filed notice to seek the death penalty. They're not going to seek the death penalty. The family have said they don't want to go for that. The Utah Supreme Court has articulated that substantial evidence exists when the evidence presented provides a reasonable basis for a guilty jury verdict. The substantial evidence standard is met when the prosecution presents evidence capable of supporting a jury finding that the defendant is guilty beyond a reasonable doubt. In addition, given that the purpose of the probable cause standard is to ferret out groundless and improvident prosecutions, the purpose of the substantial evidence standard is to ensure that the quantum of evidence presented by the state sufficiently justifies the denial of the defendant's right to freedom from pre-trial incarceration. And again, none of this is Kouri specific, so we're just going to skip because there's a lot of pages. The state lacks substantial evidence to support the charges. The state has filed no notice of intent to not seek the death penalty, nor has the time for filing a notice to seek the death penalty expired. Thus, the first charge against Kouri constitutes a capital felony, and the state must demonstrate substantial evidence to support the charge. Since then, they have said they are not going to seek the death penalty. Law enforcement never identified or seized any fentanyl or other illicit medicine from the family home. They are relying heavily on the testimony of Lauber, a known criminal with a long list of medicine-related charges. And they go into again why they think Lauber is not credible. The state has provided no evidence that there was fentanyl found in the home, nor have they provided any evidence that Kouri gave Eric the fentanyl at issue. The state has alluded to a cocktail that was prepared by Kouri in an attempt to insinuate this is the only way he could have consumed the lethal dose. However, no glass was ever tested, even though law enforcement and EMS were told upon arrival that she had mixed him a drink. That is kind of like stupid. If you're going to accuse someone of fatally poisoning someone, maybe test the glass that the drink was in. The state and law enforcement never investigated an alternative theory that perhaps Eric's alcohol and medicine use had escalated. Instead, Eric's family had pushed the narrative from the day following Eric's death that the only plausible explanation was that Kouri had poisoned him. Law enforcement simply accepted that narrative and worked backward in an effort to support it. They are heavily relying on the theory of Lauber, and then now they go into the financial allegations that are speculative at best. The state has no evidence to establish that Kouri allegedly killed Eric for pecuniary gain. Kouri owed Eric no money. They are saying that the allegation of outstanding state and federal tax liability is inaccurate. And while Kouri owed money to a hard money lender, she was current on those obligations and not in default. Oh, so the state said that she was defaulted, and the defense is saying, no, she didn't. I want to see the credit report. Thus, the financial allegations do not establish substantial evidence. Same for the drug-related charges. There's no evidence that Kouri obtained an illicit substance with the intent to distribute. Law enforcement never located fentanyl or any other illicit substance at the family home, on Kouri's person or otherwise, instead relying on the testimony of Lauber, which again, they're really trying to make sure that people know that they don't think she's a credible witness. The state cannot demonstrate that Kouri is a substantial danger to the community or a flight risk by clear and convincing evidence. Even if the state could prove that there is substantial evidence to support the pending charges, it cannot. It cannot demonstrate that Kouri is a substantial danger to any other individual or that she is likely to flee the jurisdiction. Kouri has been actively engaged with the community well before and after Eric's passing. She's participated in a local church group, assisted as a Boy Scout leader, participated in events at her children's school, and attended various local sporting events. In other words, at all relevant times, Kouri has actively contributed to society, and she is not a danger to any other individual. This case was investigated for over 18 months. Kouri knew there was an investigation ongoing. She retained counsel. Counsel attempted, with no avail, due to the actions of the state, to cooperate in the investigation. She raised her kids, maintained her business, and mourned the loss of her husband. This mere fact alone undermines any claim that the state can make with regard to either being a danger to society or being a flight risk. To be fair, she did not try and leave. She must have known they were investigating around her. She's not a flight risk. Her children are in Utah. Much of her family is in Utah. Her business is in Utah, and most of her closest friends. So she's not going to go anywhere, according to the defense. And Despite that it was clear that they were investigating Kouri, she didn't go anywhere. She stayed in Utah. Therefore, the state cannot show evidence that she is a flight risk. And therefore, the court should permit Kouri to post bail, and she should be released with pre-trial conditions set by the court. Which is what this is about now. We're almost there. Thank you for sticking with me. This is a big one. So, what were they going to ask for? So, the conditions that they wanted for bail, the individual's appearance in court when required, the safety of any witnesses or victims of the offence allegedly committed by the individual, the safety and welfare of the public, and that the individual will not obstruct or attempt to obstruct the criminal justice process. Okay. The court has several combinations of conditions that it can impose. It could impose requiring Kouri to not commit a federal, state, or local offence, avoid contact with any victim, and blah, blah, blah. And then they say Kouri is not a potential danger to any individuals or the community. She was not on probation or parole during the time of the alleged conduct, and there is no indication that she would flee the jurisdiction. The overwhelming weight of the evidence currently before the court suggests that Kouri would comply fully with any and all conditions set for her release. Accordingly, the court should release Kouri and designate a set of conditions to be imposed while she awaits trial. And that was the 9th of June 2023. Ultimately, the bail was denied due to the seriousness of the crime. You know, she is charged with murder. So that was one of the reasons. Another reason, I believe, so one of the conditions that they set out in this is that, you know, if she's granted bail, Kouri will behave and not commit any further crimes. Well, following her arrest, she was charged with some financial crimes. So that broke that condition already. Allegedly. So that's what the defence wanted. They put their argument forward. To be fair, there's all the witnesses from Greece that say nothing happened. There is the fact that there was no fentanyl in the home. They didn't test the glass that Eric was drinking from. I cannot get over that. Like oh. So they have some good points. I will give them that. But the only other option is that Eric did it himself. From what I understand, fentanyl is not a nice way to die. There was no note. He had 3 children. He had a good business. They were doing well. Apparently their relationship was really good at that time. But it's just the internet searches, Kouri, and the Walk the Dog letter, which is part of a novel. None of that looks good. So I get where they're coming from. But we will see. As I've said numerous times before, she is presumed innocent right now. We have no trial date. The judge told the defence and the prosecution to get themselves sorted for December sometime, because he's getting sick of it. He's getting sick of all these motions. He's like, no, can we just go to trial? And he's being really fair. I like this, Judge Mrazek. If you got this far in the video, thank you. I genuinely appreciate it. This was a long one. They have really tried to get bail. They did fail, but they tried. And that's their job. They did their job. So thank you. If you liked this video, make sure to like the video. Leave a comment. Has this changed your mind? Are you seeing something in a different light now? What do you think? Obviously, it was denied. We know that. But in regards to the whole case, what do you think? Did you learn something new? But that's it. Don't forget to subscribe to my channel so you never miss an upload. And I'll see you in the next one.